With reproductive rights now clearly under risk, there's a common misunderstanding about a potential solution for women who live in states where abortion will become illegal. They can just travel to another state where it is legal. But that's far more complicated than it sounds for a number of reasons. The first one is money. The Brookings Institute notes that low-income women are more than 5 times as likely than affluent women to experience an unintended pregnancy. If Roe is overturned, we know it will impact poor women the most. And those women won't have the means to just hop on a plane to California or New York. But regardless of means, there could be another potential roadblock for women who want to travel out of state to get an abortion. In her new piece for New York Magazine, Erin Carman writes about the ways in which Republicans are already trying to stop that solution. She notes that in March, anticipating the very decision that Justice Alito drafted, a Missouri lawmaker introduced an amendment that copies Texas's bounty hunter law to allow private citizens to sue people who help abortion patients leave the state. Joining me now is Erin Carman. She's a senior correspondent at New York Magazine. She's also the co-author of the book, Notorious RBG. Thank you so much for being here. Republicans, they know that many women are leaving states that have banned abortions to get abortions elsewhere. After Texas banned abortion at 6 weeks, nearly half of Texas abortion patients went to Oklahoma for abortions. But Oklahoma said, I'm going to use Texas as a template and create our own 6-week ban, which ultimately will ban all abortions once Roe is overturned. Erin, are we about to see a battle royale between red versus blue states when it comes to a fundamental right such as the right to choose?
Katie, I think that's the right way to put it. Now, I think it's important to note that although the barriers that you described are very real and are very in place now, the piece is sort of looking ahead to what might happen if this draft opinion indeed becomes the law. Because what the draft opinion says is that, don't worry, this is all just going to go to the states, and a red state might have a different, set of laws than a blue state. Of course, many of these laws are already on the books, so we really don't need to guess what California will do versus what Mississippi will do. So we know for sure that states are going to have very different laws. What we don't know is what is going to happen if there is a challenge between these laws. To your point about the battle royale, this would be several steps down the line. It's important to sort of interrogate the assumption that the conflict over abortion in the courts and in the legislature, if not in people's lives, will not end just because this opinion says, well, it's easier to just leave it to the states. And that's because, according to law professors who have written about this, and also according to history, when these kinds of state-by-state laws existed, for example, in the realm of race, there's an undeveloped set of precedents about what happens when one state's law is in conflict with another. So if somebody in Missouri travels to Illinois and their abortion is legal in Illinois but illegal in Missouri, how much can Missouri do to try to stop them? And how much can they go after, for example, a fund, someone who helps them drive? How much can they help? How much can they put roadblocks in their way when they come back to try to find out what happened to their pregnancy? These are so far hypotheticals, but they are very much within the intention of the anti-abortion movement, because if they genuinely want to stop abortions, then they won't stop with their state borders.
Legally speaking, criminalizing conduct like one state's resident going beyond that state's borders to seek relief in another state, it's complicated. That's an understatement. Do you have any predictions on how all of this will actually play out in the judicial system?
Well, I mean, interstate commerce is supposed to protect conduct like that. But what you hear from legal scholars is that and again, there's a very important paper written by David Coben, Rachel Reboucher, and Greer Donnelly that I quote, and I interviewed them for this piece. And basically, they lay out that it really depends on how a particular judge or a set of justices interprets this. Of course, Roe v. Wade has been the law of the land for 49 years, and it seems, based on this draft opinion, that it is very much a threat. So I think it's important not only to think about what's going to happen today or the next day, but what's going to happen the day after that, and how the law might shift in a direction. There could be a national ban. That's something that Senate Republicans are already talking about. Or there could be this attempt to pursue people who either aid and abet or have abortions outside of their state borders. But I think it is at least important to listen to their intentions, because it's their intentions that brought them to this point where they appear to have 5 votes to overturn this 49-year-old precedent.
In your most recent piece, I was startled to read how you note how Missouri State Health Director testified that he had, quote, compiled a spreadsheet of Planned Parenthood patients' last menstrual periods, purportedly to track whether they had complications. In this kind of big brother-esque tactics, they're used in places like China and Poland to keep track of whether women are abiding by abortion restrictions or not. But this is America. How can this kind of police state conduct be allowed to happen?
Well, I think, abortion law concerns figuring out what are the rights of the individual who's pregnant versus the state's interest in fetal life is how it has been portrayed. And so a state health inspector has the right, for example, for as long as abortion is legal in Missouri, has the right to inspect information from an abortion clinic, which is how that state health director got access to it. It's not covered by HIPAA. It's not covered by medical privacy laws because, again, they're the state that regulates that medical clinic. They also regulate other medical clinics like GYN or OBs who might be able to find out or who might have registries of who is pregnant and who isn't. Again, these are several steps down the line, but it's fully possible that in the name of, quote, protecting fetal life or potential life, which is the legal language that's been used before, you could see an extraordinary amount of surveillance. And if those pregnancies then do not result in live births, in other countries, China and Poland are two that I mentioned that have formal registries. In El Salvador, women have been jailed for being suspected of ending their pregnancies on their own when they describe themselves as having a miscarriage or a stillbirth. And so once pregnancies are being scrutinized in such a way by the state, I think anything is up for grabs.
States like Connecticut, though, they are blessedly going in the opposite direction. Connecticut just passed a law that protects abortion providers and also, quote, modifies the state's extradition statutes and prevents an out-of-state patient's medical records and other evidence from being disclosed. Do you think things like these kinds of laws will have actually even a more beneficial effect, maybe persuading red states to reconsider their own abortion laws if their efforts are being thwarted by some blue states?
I don't know about changing what red states will do, but I do think that in blue states where there are governments that are sympathetic to abortion rights, they have tools that they so far haven't used. And so Connecticut, where one of the law professors who wrote the paper that I mentioned that inspired my piece, testified on behalf of that bill in Connecticut. There are certainly tools that haven't yet been used to protect access to abortion that states like California and Connecticut, and now there's some conversation in my home state of New York about using them, whether it's to help individuals who are traveling from red states access funds or to protect providers in blue states who are going to get an influx of people, to protect them from the kind of legal action that's already being threatened against them for giving services to individuals who are coming from hostile states. So for a long time, even New York State had its pre-Roe laws on the books. It actually took Trump getting elected for Democrats in New York State to take off the pre-Roe abortion bans that existed before. So I think this will be a reminder to folks in states that are sympathetic to abortion rights that they can't just assume that the court will have their back, and they need to be proactive if what they want is for citizens to be able to access abortion services.
Wren Carmon, thank you for your time and for your insight today.
Thank you.